rise in favour. This is an appeal in the matter of Fridman and Agrofirma and another.
Yes, Mr. Craig.
Madam, good morning. This is an appeal, as you know, from a decision of Mr. Justice Bryan in
Yes.
the Commercial Court. The essential question which arises on the appeal is whether CPR Rule 6.9 itself provides a source of jurisdiction by reference to a residence test, or whether it simply provides a method by which service is to be effected on a person over whom court has jurisdiction by reason of his or her presence here. Now, we say the learned judge who accepted that there was a common law test requiring satisfaction before the court could exercise jurisdiction was wrong to conflate presence with residence. The respondents say, although it wasn't a point advanced below, or indeed by way of a respondent's notice, the CPR has effectively swept away the common law test, and that one only needs to look to see whether the requirements for CPR 6.9 are satisfied. Ultimately,
Do you maintain your objection to that point being raised?
because in my submission, it's two sides of the same coin. And so the question essentially is it necessary for a person to be present in the jurisdiction at the time of service, as distinct from being resident here, in order for the court to exercise jurisdiction over him?
Right, but you don't object to them running that point?
And our fundamental point is it is necessary for a person to be present here.
Mm-hmm.
And we make four main points in support of that submission. First, the jurisprudential basis of jurisdiction that the service in rules seek to address is the foundational right of a state's jurisdiction over its own territory. That is founded upon a person's presence in the territory. It catches all those who are within it, but only those within it. And we say it is fundamentally incoherent to assert jurisdiction over a person founded upon territorial jurisdiction where that person has been ejected from the territorial jurisdiction and is prohibited from returning to it or being present there. The third point we make, the second point we make is that the service in rules in section 2 of part 6, including those under CPR 6.9, deal with only how a person can be served, not when it can be served. The third point is that the common law requirement of presence is soundly rooted in history and hasn't been displaced by the provisions of the CPR. And fourthly, we say, if, as the respondents contend, the service in rules define when the court has jurisdiction, that would mean, in my submission, this court would have an exorbitant jurisdiction. It would mean the court would have jurisdiction over anyone who resided here for however short a duration, however long ago, and however relevant to the claim at hand, because as long as the claimant is unable in that situation to identify the current address of the defendant, that person can be served at their last known residence in the jurisdiction. And we say that would reduce the fundamental basis of jurisdiction to a quirk of administration.
Well, if you're right on your first point, and the CPR purported to extend jurisdiction, the question might arise whether the Rules Committee had the power to do so.
That is also the point.
If it is a substantive principle of law,
Yes.
then the Civil Procedure Act, which allows the Rules Committee to regulate procedure, doesn't give the Rules Committee the power to change a substantive law, I would have thought.
Yes. But in my submission, when one actually looks at the rules, one can actually see that they're not concerned with what I call the when, they're really concerned with the how, and I'm going to come to that in a moment. And just to finish that point about the quirk of administration, the other point is, to make it matters even less certain, that quirk of administration wouldn't depend upon some objective test that the court could assess. That it depends upon the claimant, individual claimant, who is starting the proceeding. So a subjective assessment, because it's all about what the claimant knew about the last known residence. And so we say, if proper regard is had to the requirement of presence in order to establish territorial jurisdiction, it was not open to the claimant to purport to serve the appellant at Athlone House. Because at the time of purported service, the appellant was excluded from the territorial jurisdiction. His right to be present here had been removed.
Well, that's the same as your incoherence point,
Yes,
isn't
it
it?
is. But So with those points in mind, I intend to structure my submissions, subject to your lordships, in the following way. First of all, I was going to detail, to the extent necessary, the relevant facts and what the learned judge decided.
Well,
You may
we've
say that
read the judgment,
I'm
so
with
you don't need to spend very long on that.
Secondly, I want to look at the rules themselves and the distinction between what we say is the how and the when of service. Thirdly, to look at the origins of the common law rule. Fourthly, to consider the recent cases that have considered the requirement of presence and the relevant rules of service. And then fifthly, to explain briefly why we say the judge was wrong to conflate presence with residence. My lords, the simple point is that, in terms of the facts, is that at the time of service, Mr. Fridman, as known by the claimants, was outside the jurisdiction and had been sanctioned. So they knew he was prohibited from returning by virtue of a state act. In relation to the judgment, as you know, Mr. Justice Bryan found, first of all, the common law test was satisfied, and I don't know whether it's necessary to take you to that, but he essentially determined that the appellant was temporarily absent from the jurisdiction, and therefore, the test of residence was effectively the appropriate test to apply.
Do you accept that temporary absence does not necessarily negate presence?
Yes. That's precisely the decision that was made in SSL. And it is also, in fact, I'm going to take you, your lordships, to a decision of the Earl of Selborne some 100 years earlier,
Yes,
when he actually made pretty much the same point. So I'm going to now turn to the CPR rules themselves. Now, the respondents say in their skeleton argument at paragraph 8 that this is at tab 4, page 46 of the core bundle. They say at paragraph 8, under the common law rules, jurisdiction over a defendant is established by the validity of service of the initiating process. Now, that is wrong, because you see from the extract below, it provides that, what the extract from Professor Briggs provides, is that the jurisdiction depends upon service of process, not validity of process. But they go on to say, at paragraph 9, the rules applicable to service in the jurisdiction are contained in part 6, section 2, CPR, service effect in accordance with those rules, and therefore complete answer. But that is only, in my submission, half of the point, because in addition to the how, as it were, they have to show the when. And that indeed appears, and that point is made by Professor Briggs in the extract immediately after that which is quoted by the respondents, and it is in the authorities bundle at tab 33, page 743 of the bundle. Paragraph 21.02. You'll see that the rules, and the rules they're referring to are the common law rules of jurisdiction. The jurisdiction of the court depends upon service of process. Then we have the remainder of the quote that was cited by my learned friends, or not my learned friends, but their predecessors. And then if we also look at the subsequent paragraph, it says the common law question then becomes one of how and when the claimant may serve process upon a defendant. If the defendant is present within the territorial jurisdiction, the claimant has a right to serve him there and then. So you've got when, and then can be served. If the defendant is not within the territorial jurisdiction of the court and has not appointed an agent, the claimant has no right to serve him. Instead, permission to serve out must be applied for. So, in the former situation, the defendant is present within the jurisdiction. That is the when. Then the how is the question of the service. In the latter situation, when you satisfy a relevant rule for service out, how you do it, how you serve out, what process you actually adopt, is a matter of the how. Now, that the rules of service only apply in relation to service in to the how is apparent, we say, from the rules themselves. My lords, I don't know whether you would prefer to, should we just look at the white book? Is that the easiest way to look at the rules?
Yes, unfortunately we don't get provided with the up-to-date white book, so it's not in court anymore, and I haven't brought mine with me, but there is a 2024 version here, and I don't suppose the rules will have changed since then.
I don't think they have. For the present purposes, in my submission, they are going to be the same. If my lord looks at rule 6.3, which in the current edition is at page 236 of the white book.
Yes.
And my lord sees it's under the heading part 2, or section 2, service of the claim form. And then my lords will see the heading methods of service. Now, in my submission, that of itself points to this being a how service is to be effected. It sets out a particular procedure for accomplishing service. And it permits service to be carried out in a number of different ways, which includes C, leaving it at a place specified in rule 6.9. And then we have rule 6.9, which is in the current edition at page 248. I'm not sure whether it's the page numbering has survived. But my lords will see that the rule applies in certain circumstances, and then it says subject to certain provisions, the claim form must be served on the defendant at the place shown in the table. So it mandates a particular way in which the procedure to serve should be adopted. Now, my lords, one can compare this with section 4 of part 6, which is at page 281 of the current edition of the White Book, and it starts at rule 6.30. And the relevant rule moving through part 4, which is service out of jurisdiction, is 6.36. And my lords will see, it's page 297 of the current edition, that if any proceedings to which rule 6.32 or 6.3 does not apply, the claimant may serve a claim form out of the jurisdiction with the permission of the court if any of the grounds set out in paragraph 3.1 of PD 6b apply. So we say that this is, and I say this is what is called a when provision. And then if my lords look to rule 6.40, my lords will see what I describe as the how provision, again headed methods of service, general provisions. And then this sets out the process by which service is to be effected overseas. And in my submission, it ties quite neatly into 6.3. So it's the same provision, it's how service is to be effected. But of course, in relation to service out, the rules themselves contain the when. But in relation to service in, the when is not contained in the rules themselves. We say that the fact that section 2 doesn't provide the when is also apparent from the effect that has been given to rule 6.15 of the rules in relation to service by alternative means. And that is seen, my submission, from the decision of David Foxton QC as he was in Marisham Limited and Kenvet Limited. This is in the authorities bundle at tab 24, page 466.
I'm sorry, could you just give me that reference again?
Apologies, yes, it's tab 24.
Thank you.
And in relation to judgments, my lord, may I just ask, would you prefer the case page number, as in where the reported case page, or
Whatever's convenient.
Great. So at page 468, bottom numbering, paragraph 1, you will see that this is a case where the master had refused to set aside an order granting permission to serve an application by alternative means. And the first ground was that the master had failed to make an order in advance of that, granting permission to serve out of the jurisdiction. The rule itself is set out at page 470. And my lords will see that on its terms, it doesn't provide any restriction or how it is to be applied. Now, paragraph 17 of the judgment, which is at page 471, my lords will see that David Foxton QC, as he was, said, I'm satisfied that an order for service by an alternative method within the jurisdiction against a defendant who's resident outside of the jurisdiction can only be made if the court has satisfied itself the case is a proper one for service out of the jurisdiction and has made an order to that effect. And then you will see the submission made at paragraph 19 at page 472. Mr. Penny argued that while this might be the case where the alternative method of service itself involves service out of the jurisdiction, as was the position in Abela, this was not true of a case such as the present, in which the method of alternative service provided for service within the jurisdiction. I accept this provides a potential point of distinction, but I do not accept has the effect the source of the power to order service by an alternative method as against a defendant out of the jurisdiction differs depending on whether that alternative method of service in question is one providing for service within or outside the jurisdiction. And you will see that subparagraph 1, he says, if it was correct, then the only order establishing jurisdiction of the court over the tenant would be the order under 6.15. However, it's clear that it is not a provision capable of establishing jurisdiction. And equally, we say neither is Rule 6.9, or for that matter, Rule 6.3. And a further point that we make as to why usual or last known residence cannot found jurisdiction is also clear from the service out rules. And my lords have the practice direction 6B, which is at page 338 of the current white book. Paragraph 3.1. And my lords will hopefully see paragraph 3.1, claimant, this is where permission is required. Claimant may serve a claim form out of jurisdiction with the permission of the court under Rule 6.36 where, and my lords will see the first one, a claim is made for a remedy against a person domiciled within the jurisdiction within the meaning of sections 41 and 42 of the CJJA. Now, the test for domicile for these purposes is neatly summarised by Mr. Justice Barling in Schulman and Kolomoisky. Now that is at tab 25 of our bundle. And the paragraph that I'd ask you to please turn to is at page 494, paragraph 9. It refers at paragraph 9, bottom of the page, to the Brussels regulation, provides person domiciled shall be sued in the courts of the state. And then Article 62.1 provides, page 495, this is the quote, in order to determine whether a party is domiciled in a member state whose court has seized of a matter, the court shall apply its internal law. And then at paragraph 10, domicile is to be assessed not by reference to the common law test, but by specific rules. By virtue of the applicable UK rules, a person will be domiciled in the UK if 1, he's resident in the UK, and 2, the nature and circumstance of his residence indicate he has a substantial connection with the UK or that part of the UK. Subject to proof to the contrary, the latter requirement is presumed to be fulfilled in case of an individual who is resident in the UK or a particular part and has been so resident for the last 3 months.
So that's not the common law test.
No, that's not the common law test. That is the test for domicile under the regs. But what the point I'm going to make about this is that the test for domicile, where satisfied, is one where you have to get permission to serve out, potentially. But it requires more than just a residence test. It's not sufficient that you're resident here. You also have to show a connection, substantial connection, which prima facie is you've been in the jurisdiction for the previous 3 months. But in my submission, if the respondents are right, and they say it's all down to residence, that's all you need to look at, then this provision is rendered nugatory. Because this provision makes clear that residence isn't enough in my submission. And so coming full circle on the rules, it's no doubt in my submission for this reason that in Dicey, Morrison, Collins at, this is in bundle tab 35, page 753. My lordships will see Rule 32 expressed, it says the court has jurisdiction
Yeah.
entertain a claim in personam against the defendant who is present in England, so that's the when, and duly served there with process, that's the how. And then again, coming back to the point made in the respondent skeleton, they focused only on the duly served bit, and they're ignoring entirely the when.
Despite the eminence of Dicey, Morris and Collins, I imagine that presence in Wales would be good enough.
I think that's probably right, yes. So I've now turned to the third part of my submissions, which is simply the origin of the common law rule. Now, the history of the common law requirement is, in my submission, quite neatly traced in the relatively recent judgment of His Honour Judge Matthews in a decision in Broome. That's at tab 27 of our authorities. And it is a case essentially where a liquidator sought to serve proceedings on a defendant who, prior to the service of those proceedings, had moved to Spain. And the learned judge decided on the appeal that as the defendant was not present in the jurisdiction, and an order for alternative service had been made, the court didn't have jurisdiction over her. And then, if I could ask my lords to turn to paragraph 64, which is at page 553 of the bundle. And my lords will see at paragraph 64, His Honour Judge Matthews refers to the early common law rule in relation to jurisdiction only where there was an original issue of an original royal writ. And then we have the passing of the Uniformity of Process Act in 1832, which replaced the multiplicity of originating processes and commanding the defendant to enter an appearance. And then those circumstances, judgment could be obtained in default of appearance. And then it says at paragraph 64, thus the rule the court acquired jurisdiction by the appearance of the defendant was in effect replaced by a rule it acquired jurisdiction over a defendant who was served with process while physically within the territorial jurisdiction. Later cases established didn't matter in the case of a person served whether he was also domiciled or resident or whether he was there at the time of the issue of the writ. Then it refers to the supplemental rules subsequently being developed in two quite different directions. The first was to give the English court jurisdiction in certain cases over persons outside the territorial jurisdiction, which is what we've looked at in obviously part 4 of the current CPR. And it refers to the current rules being there. And then the second point is the forum non-convenience arguments that can be run. And then paragraph 68 says, notwithstanding these two developments, the basic rule remained. Now, with respect to that basic rule, in my submission, there is a clear exposition of it in the judgment of the Privy Council in Singh and the Raja of Farrakot. That is at tab 2, page 14 of our Bible. And the judgment of the Earl of Selborne starts at page 682 of the judgment, on 19G, looking at the bottom of the page. Now, this is the case where the plaintiff, having obtained a judgment from the court of Faridkot, sought to enforce them in Lahore. And you'll see at the foot of page 682, a reference to the facts, the appellant was for 5 years, beginning 1869, in the service of the late Raja of Faridkot as his treasurer, and the causes of action on which the suits in the Faridkot Court of Law arose within that state and out of that employment. Claims made in each of the suits, merely personal, money alleged to be due, etc. And then it says, this next paragraph, the appellant left the late Raja's service and ceased to reside within his territorial jurisdiction in 1874. He was from that time generally resident in another independent native state. He was then served in Jind, in that state, with process of the Farid court and didn't respond to them. And final paragraph on 19H, my lords will see that he says, under these circumstances, there was in their lordship's opinion nothing to take this case out of the general rule.
You needn't read it aloud.
I'm
sorry.
good.
How far do you want us to read? Just the sideline part?
If my lords can read first of all to it's to page 684, second paragraph, end of the second paragraph, with
Starting in a personal action.
yes.
Yeah. Yes.
So, my lords, the simple point is this, or one of the simple points is that this idea of territorial jurisdiction isn't a modern concept. It goes back to Roman law. And I ask you, I'll come back to this point to note, if I may, the final half sentence at the top of page 684, which refers to the fact that no territorial legislation can give jurisdiction which any foreign court ought to recognise against foreigners who owe no allegiance or obedience to the power.
Yeah.
My lords,
In answer to a question earlier, you said that temporary absence was something that was dealt with in this case?
yes, I'm going to take you to that now. And then, my lords, if I could ask my lords to look at the principle that was suggested at the bottom of the page, 19I, was effectively that where somebody had a contract in the jurisdiction. My lords, the best thing is to ask you to read the bottom of the page, the conclusion of the learned judge in the Chief Court of
yes.
Punjab. Yes. I'm going to ask you just to read that, and then overleaf.
Yes.
To the end of the second paragraph on that page. And my lords will see, I hope, the passage which I alluded to earlier. Although he was in fact temporarily absent, he might, as the holder of such an office, be regarded as constructively present in the place where his duties required his presence, and therefore amenable to the jurisdiction.
Yeah.
And then one of the reasons for the exercise of the jurisdiction only over those people within the jurisdiction, as expressed by the Earl of Selborne, is neatly expressed by the Court of Appeal in Adams and Cape Industries. And that is in the authorities bundle behind tab 11 at page 211. Bottom right hand numbering. And if I could just ask my lords to read that paragraph that's highlighted to the end.
Sorry, which page?
I apologise. It's page 211 of the red numbers.
Yes. I noticed also that the court on page 209 of our bundle quoted Lord Parmore, also on the question of international law and jurisdiction.
Yes. Yes. To be frank, I think it is in my submission, it's a long established principle which is referred to repeatedly in the cases. So, and we say, I mean, it's the point I made earlier, it's incoherent in these circumstances to say that you can have jurisdiction over a person who's prohibited from
Yeah,
being
no, we've
present.
got that point.
Yes. My lords, I now turn, as it were, to what I've described as the recent cases, although some of them go back a few years, because I want to start with the case of Barclays Bank and Hahn. That is at tab 10 of the bundle. And the House of Lords decision starts at page 118 of the tab. And my lords will see at the top of page 120 or 508 of the actual law report paging, second paragraph down, Mr. Hahn is a national of the Republic of South Africa, who has a home in England, accepted as non-resident for tax purposes. He doesn't stay in England for more than 6 months, but he is there for 3 months, a year, sometimes longer. He was served, as you'll see at the bottom of the paragraph, essentially while he was en route to England in an aircraft. The writ was served at the property in England at the time he was mid-air, and he arrived at Heathrow and was told, oh, there's somebody tried to serve something at the property. So essentially he didn't go to the property, went to a hotel and then left the jurisdiction. And my lords will see that at page 121, the relevant rule that the court was considering, top of the page, a writ must be served personally on each defendant by the plaintiff or his agent. And 2, a writ for service on a defendant within the jurisdiction may, instead of being served personally on him, be served A, by sending a copy of the writ by ordinary first-class post at his usual or last known address. So very similar to usual or last known residence. And my lords will see the argument that was advanced by the defendant was that, it's below the quote from the RSC, was the Supreme Court, it is Mr. Hahn's claim that it was not duly served on him because in its true construction, the order requires the defendant should be physically present in the jurisdiction at the time of service. Put shortly, it was argued on Mr. Hahn's behalf, jurisdiction of the court entertaining action pursuant depended historically on the defendant being served personally, and when the rules were amended, it wasn't intended to alter the substantive jurisdictional requirement of presence. Now, the bank contended at the bottom of, so letter H on page 121, and then if I could ask my lords to read over onto the end of the first paragraph on page 510.
Yes.
And my lords will see effectively the same argument was being run there as is being run here. It was said the writ that is marked for service not outside the jurisdiction, or writ for service within the jurisdiction, can properly be served on a defendant who is outside the jurisdiction, providing requirements of the order of field. That's to say, the letterbox must be located at the usual address of the defendant or at his last known address. And then there's the additional requirement of plaintiff needing to depose that the writ's been brought to his attention. At 510 H, just below H, the bottom paragraph, it was accepted by Lord Brightman that the appellant's proposition defendant must be within the jurisdiction at the time when the writ is served. In other words, something more than the usual or last known address was required. And then Lord Brightman goes on to say, because he's disagreeing with the decision of the Court of Appeal, that he doesn't agree with that approach, because that approach would mean a writ could be validly served under Order 10 on a defendant who once had an address in England, but had permanently left this country and settled elsewhere, provided those conditions were met. And my lords will see that he says, this appears to me to outflank Order 11 in every case where the defendant was formally resident in this country and is capable of being contracted abroad within 7 days. Now that's precisely the point we make on this appeal. Now ultimately on the facts, the House of Lords determined that there had been proper service because it was brought to his attention when he was actually in the jurisdiction.
Yes, I mean, I think the reasoning is of quite considerable importance, particularly since later cases have treated it as simply having been decided on the construction of the RSC, which in a sense it was, but the particular construction Lord Brightman adopted was to fasten on the words unless the contrary is shown.
Yes.
That's the point of construction on which the case turned.
Yes. It definitely
In other words, the construction tied in with Lord Brightman's acceptance that presence at the moment of service was required.
Yes. Yes. But also the other point to make, because there's a distinction in the next Court of Appeal case which we'll look at, which is the Wolf case. Here, it was firmly placed in the House of Lords' mind that there is the requirement, the long-standing requirement for presence within the jurisdiction. That part of the analysis was there at the background, as it were, of the process of construction, which in my submission it was not, as we'll come to in the decision in Roll. Just pausing there, that there is the potential problem, if my lord looks at page 122, we have the problem cited by Lord Justice Parker.
Yes.
About the person going across for lunch. And that, of course, is answered by the flexible idea of temporary absence not negating presence. Now, my lords, the next authority is, as I said, Ralph and Zola, which is at tab 12 of the bundle. And the facts are set out in the judgment of Lord Justice Dillon at page 1308 in the weekly law reports page number, or page 268 at the bottom of the page. I mean, essentially, it was a claim by a builder for money said to be due for works carried out to a property in London, owned by the defendant just before the expiry of the limitation period. But the defendant had several years previously emigrated to Spain. And the writ was served by post on the property, and it was forwarded to the defendant. And then the defendant challenged it on the grounds there had been no proper service. The relevant rule under the County Court rules at that time is set out at between letters E and H of the report. And then the judgment itself starts at page 271, so with the essential issue. And my lords will see, first of all, that Lord Justice Dillon refers to the decision of Barclays Bank of Swaziland and Harm. It says the rules under the RSC provide for service within the jurisdiction, whereas that's not something which we see on its face in the RSC. So the crucial question is whether a similar limitation has to be read into Order 7, Rules 1 and 10 in order to limit service to service on defendants who are physically within the jurisdiction. Letter E refers to separate provisions, which I don't think is relevant. And then between letters F and G refers to the rules of Supreme Court introducing postal service for the first time in 1979. But then he says that in relation to the county court, the rules is more complicated, or history is more complicated. He refers to the way in which they came into force, where the present wording derives from, and then overleaf at page 1313, you'll see his consideration further of what it is said. And then, my lords, will see the concluding paragraph beside letter D. Against that history of the rules, I find it impossible by any process of mere construction to limit the scope of present Order 7, Rule 1 and 10 to service only on a defendant within the jurisdiction, by analogy to RSC Order 10, Rule 1. Now, the point there to make is that that process of construction did not involve any submissions on the when point. It didn't involve any submissions on the existence of the common law rule in relation to the requirement of presence. All that Lord Justice Dillon was looking at was the rules themselves. In my submission, that's clear from the judgment. And that is ultimately, in my submission, the problem which then carries through into the decision of Kamali and City Properties, because much reliance is placed on this decision in circumstances where, in actual fact, no consideration was given to the existence of the common law rule. My lord, on this case alone, I would also suggest it created a very unsatisfactory outcome, because it meant the territorial jurisdiction of the court depended upon whether or not you issued in the county court or the High Court. Well, the next decision is that of Mr. Justice Lawrence Collins, as he was, in Chalaram and Chalaram. That is at tab 14, starting at page 283 of the bundle. And it was a claim for what were alleged to have been breaches of trust under 4 settlements. And my lords will see at page 287 of the red numbering at the bottom, all of the defendants, paragraph 4, top of the page, are alleged to be outside the jurisdiction. 2 were purportedly served by the posting of the claim form and particulars to addresses in London. Now, among other things, the defendants who had purportedly been served by post applied for declarations that service was not properly effected. And my lords will see at page 291, paragraph 31, Mr. Justice Lawrence Collins, as who was, says, the principal issues of these, the first is whether the CPR have effected a major change to the rules of jurisdiction so that a defendant who is not domiciled or present in England can now be sued here by virtue of service on him at his last known residence. he refers to the effect, whether the effect of the decision in the House of Lords in Barclays Bank and Harm was only permissible if the defendant was in the jurisdiction at the time of service. And my Lords will see at paragraph 36 on page 292. He cites the and refers to the decision in Barclays Bank, Swaziland and Hahn, and then the claimants in the case, my Lords will see at paragraph 45, page 293, said there is no fundamental rule of procedure that a defendant outside the jurisdiction can't be served within it, and they relied upon the decision in Rolfe and Solon. And then at page 294, my Lords, I can just ask you to read paragraphs 46 and 47, which you may already have done because I
Yes.
think most of it's already been referred to in the skeletons. But the key point is that there are two separate reasons given for why the court, why there's not been valid service. The first is that obviously the residence point of itself, but then secondly, a separate point is the fundamental rule in relation to the requirement of presence. And that judge decision that CPR 6.5 has not swept away the general principle.
Yes.
Now, my Lords, the next decision is the decision of Mr. Justice Evans Lowe in Fairmays and Palmer. That's at tab 16.
Does we get much help from that? That predates Kamali, doesn't it?
It does predate Kamali. And all I would say about that decision is that, first of all, in that case, there was agreement that there was domicile, and yet, notwithstanding that, as I say, that domicile test is higher than simply residence. And also, in that case, Mr. Justice Evans Lowe made quite clear, paragraph 15, in his view, that residence was material for the purpose only of CPR 6.56. And then at paragraph 16, this is the point which deals with a subsequent point that's raised by Lord Justice Newberger. He says, at paragraph 23, the master drew attention to the difficulties of claimants seeking to serve proceedings on a defendant who didn't have an accepted address for service. And he says, it seems to me it can be met by the issue of concurrent proceedings for service abroad. And that's precisely the point. That is the answer. If you can't find the address, you still have to apply for service overseas. Now, my Lords, the next case, and it's really the case that I have to deal with head on, is a decision in City and Country Properties in Kamali, which is at tab 15. And my Lords will see from the judgment of Lord Justice May at 326, or the red numbers. And Lord Justice May says, in my view, the appeal raises only one point of substance. That's whether the second part of the judgment of Lawrence Collins J in Chalaram is or is not correct. And he said, Lord Justice May says, in my judgment, it's not correct intrinsically and because it fails to follow and apply the decision of this court in Rolfe and Zolan. Now, although as we've seen, and the submission I make, is in actual fact the Court of Appeal in Rolfe and Zolan didn't actually consider the common law rule. Now, in this case, City and Country Properties, the landlord brought proceedings in the county court against the defendant and served on what was his place of business in Middlesex. At the time of service, he was overseas, and the defendant contended he was not properly served because he was not, at the time of service, in the jurisdiction. And then, my Lords will see at page 327, at paragraph 6, Lord Justice May if I can ask my lords to read that.
Yeah.
And through to, for now, paragraph 10, if I may. You may already have looked at this in some detail.
Yes.
So effectively, he's saying on the construction of our current CPR rules, then it's the same as the county court rules. And then at paragraph 11, he refers to the fact there's a new code, etc. And then at paragraph 12, he determines there is no longer a fundamental principle, such as was suggested by Lawrence Collins, J. And it said the reasoning in Rolf's case applies without qualification to part 6, which are, so far as relevant, the same as the former county court rules. In my submission, the learned judge was wrong to do so because he failed to actually identify the fact that in Rolf and Zollern there was no consideration of that principle at all. And you'll see the point that was made by the appellant, in that case at paragraph 14. Service under defendant has to be within the jurisdiction at the time is an entrenched principle which cannot be abolished by an inexplicit sidewind and secondary legislation. We make the same submission before you on that point. Now, with the greatest respect, Lord Justice May, you failed to appreciate in my submission the need for the when as well as the how.
Yeah. If you look at page 324,
Yes.
you'll see the cases that Mr. Wallman seems to have relied on,
Yes.
none of which include either the Singh case, which you referred us to, or Adams and Cape.
No.
So I'm not entirely sure what the argument was.
No. I think it's fair to say that Lord Justice May thought it was overly long and not terribly convincing, but as you say, it's difficult to see what the basis upon which it was said that requirement for presence was actually established. And then at paragraph 15, now that service by post is met, it makes little sense that its effectiveness should depend on the chance the defendant happens not to be abroad. Sorry, happens to be not to be abroad at times if service is in accordance with the rules. Well, again, that's the flexibility point. That's the temporary absence point, which is subsequently the way in which Lord Justice Stanley Burnton reads the rule as expressed by Mr. Justice Lawrence Collins. Now, the judgment of Lord Justice Neuberger starts at page 330 of the bundle. And paragraph 19, Judge refers to his agreement with the reasoning of Lord Justice May, but says that the reasoning of Lawrence Collins J and Clara needs proper consideration. And then paragraph 20, Lord Justice Neuberger says the words of the relevant provisions do not appear to exclude service in accordance with their terms, simply because the defendant is out of the jurisdiction. But in my submission, that begs the question. Equally, the rules don't state for example, even if the defendant is out of the jurisdiction, service can be affected. And that goes back to my how and why point. At paragraph 21, he refers to the decision in Rolfe and Zolan and says, consistent with the approach in that case, inappropriate to imply the common law principle. But as we've already discussed, that case doesn't actually decide the common law principle. Paragraph 22 of the judgment, it said rule 6.15, which doesn't fall within section 3, and provides that where a contractual claim is brought, the claim form may be served by a contractually agreed method. Suggests the provisions outside section 3 of CPR part 6 were intended to be capable of applying even where the defendant was out of the jurisdiction. Now, but that is a different point, because that is a situation where the defendant has consented to be served. My lords, I realise at this point in time that this decision may be easier to read if you have the relevant rules from 2007. I do have copies of them if my lords would find that of assistance.
Well, if you think it will help, sure.
It's a cross-check as well, just so my lords are aware where things have moved to. The rules are effectively the same, it's just now we have service of the claim form separate from service of document.
Yeah.
Now, the fourth point, paragraph 23 of the judgment of Lord Justice Newberger. He says, fourthly, nothing in section 3 of CPR part 6 appears to me to preclude service on a defendant out of the jurisdiction being effected in accordance with rules 6.2 to 6.5 where it's appropriate. The terms of rule 6.5 appear to be mandatory, whereas the provisions of rule 6.20 appear to be expressed permissively. Now, with the greatest respect, that is because rule 6.2, as it was, which is now rule 6.36, is a when provision. And my lords will have that it's at page 208 of the clip that I've handed up. And it's in essentially the same terms as our current 6.36.
Yes.
And then, as with our current rules, if my lord turns to page 229, it's the same provision that we've got currently, method of service again, and that is the how provision again, which the learned judge wasn't taken to. And of course, the reason why you wouldn't have a mandatory out of the jurisdiction service provision is of course because it depends, that the process of serving out of the jurisdiction depends upon the relevant rules in the foreign jurisdiction. So it'd be wholly inappropriate for this court on this jurisdiction to mandate how something was to be served in some other jurisdiction. But again, the rules, and my lords will see, the old rule at the beginning of this, page 172, 6.2, again, is headed methods of service. My lord then has at paragraph 24 a reference to the Lugano and Geneva Conventions not affecting matters. I don't think that takes the argument any further. I apologize, I've missed one point. The at paragraph 23, halfway through the paragraph, reliance was placed by Mr. Woolman on the fact that Rule 6.201 refers to the claim made against a person domiciled in the jurisdiction. Now, that's the point that I made at the outset of my submissions. And Lord Justice Neuberger says it doesn't render the provision neutral, but in my submission, it has to, and it does, with all due respect to the learned judge, for the reasons that I explained earlier. Paragraph 25 is the question of the overriding objective. And if I could ask my lords to read paragraphs 25 and 26.
Could you just explain the last sentence of paragraph 26?
Well, under the rules.
Well, just where in the rule do we find that? Just looking at the rule.
Yes, this is the old rule.
Yeah.
It is at
You may not have the complete rule. Not least because the end of page 177 says the document must be sent or transmitted to or left at the place shown in the following table, and we don't seem to have the table.
no.
Anyway,
My lords, I will. Apologies for that. I didn't bring the full. Obviously, the full copy hasn't arrived. But the provision, relevant provision, echoes entirely what is currently 6.9, and it's basically 6.93. And 6.94. I will provide you with a copy of the rule, but in my submission it's exactly the same. Now, the point I make about what's expressed there is, in fact, that is contrary to the view of Lord Brightman, as expressed in Barclays Bank and Swaziland, and because it essentially that's outflanking our current Rule 6.36. And as I say, that in my submission is wrong because it founds jurisdiction, as I said at the beginning, on a quirk of administration, and a quirk of an administrative act carried out not by on any objective analysis, but simply by what the claimant does. Paragraph 27 refers to the fact that the claimant can, having not found the defendant, can issue proceedings and proceed. If that leads to judgment, defendant can, providing he acts promptly, apply to set aside. But with respect, why should the defendant in such circumstances accept the jurisdiction of the court if there's no jurisdiction over him or her, no territorial jurisdiction over him or her, then there's no reason why somebody should have to come and say that. Paragraph 28 deals with the so-called compensating factors. And in my submission, that is dealt with by the subsequent cases, which refer to temporary absence not being something which negates presence. Paragraph 29 is the point where it said it's unfair because the defendants disappeared. Well, as I said, and the answer that's expressed by Mr. Justice Evans Lowe in that situation is that you simply need to apply for service out, which indeed happened, my lords, in this case. In the alternative, there was an application for service by alternative means, which was made, and that was effectively abandoned before the hearing before Mr. Justice Bryan, on the basis that it was accepted that before they could get service by alternative means, they would need to apply to serve out. And that's, if you need that's actually recorded in the judgment of Mr. Justice Bryan. Paragraph 30 of the judgment talks about this particular case.
Yeah.
And that's absolutely right. Paragraph 31 refers to the point about the rules providing effectively a complete code. Oh, paragraph 31 and 32. And for reasons I've already expressed, well, we don't accept that the learned judge was right to find that. And then there's an attempt to distinguish at paragraph 33 the decisions invoked by Lawrence College J, but I don't think it's necessary for me to say anything further about those. And then finally we have the judgment of Lord Justice Wilson, who my lords will see agrees with Lord Justice May and Lord Justice Neuberger. But then he has this, as it were, postscript, particularly because of my disinclination to accept, without express mandate, that inquiry into the validity of service abroad should depend upon where the defendant turns out to have happened to be present on the day of deemed service. And indeed, my concern, the inquiry would then degenerate into a difficult assessment of the truth of his assertion. So what his concern was essentially, well, you can't have what I could describe as the Scottish effect, or the Scottish lunch effect. And that is obviously answered by the subsequent tweak, if you like, given by Lord Justice Stanley Burnton.
Yeah.
And my lords, finally we have the decision in SSL, and that's at tab 19, page 383. And it was a dispute between joint venturers, and the defendant was a company incorporated in India, and so no individual defendants. And the claimants commenced proceedings by serving the claim form personally on one of the directors of the defendants in London. And the question of appeal was whether or not that was effective service. And my lords will see at page 393, paragraph 42, there was a consideration of a decision under the previous rules of the Supreme Court. And then at paragraph 48, you will see at page 395, the argument was that the Odehos correctly stated the law, but principle doesn't apply to the equivalent provision of the CPL. The rule is clear and unqualified and should not be read down in the way that the RSC rule was. And then at paragraph 49, it's ruled, in my judgment, no good reason has been shown for the principle enunciated in Theodotos, which represents a fundamental rule of the common law, to have been excluded from the application of the material identical provision in the CPR. So just pausing there, different provision under the CPR, but you can't just read it at its face value. It carries with it common law principles. And my lords will see the halfway through that paragraph, just above letter F, with the words beginning, moreover, for our courts to exercise jurisdiction on a personal company that owes no allegiance to this country and is not present in it in any meaningful sense is not to be lightly assumed. A company served must, if it's to avoid a default judgment, incur the burden of coming to this country to apply for the proceedings to be stayed, even if the claim has no connection with this country at all. And of course, that answers, in my submission, the point that was made by Lord Justice Newberger in Kamali about the defendant can always come along and set aside the judgment. My lords will see at page 396, paragraph 53, reference to the facts of Ralph and Zolan being extraordinary. It refers to the facts themselves, then says just beside letter C, those facts were, on the court's interpretation of the county court rules, irrelevant. In good service, even if defendant had no property in the jurisdiction and had never received the summons, and presumably even if he'd emigrated much more than the 5 years that had elapsed. Held good service, no issue raised, and says appeal could have been decided on a simple basis. Court will normally set aside default judgment if the defendant shows a good defence. Then it refers to paragraph 54, city and county properties. And the disapproval. Then at page 398, paragraph 56, Lord Justice Stanley Burton makes quite clear, agrees with the decision, and makes quite clear there are obvious reasons why that person was present in the jurisdiction. And then at paragraph 57, it said, reiterates, I might ask you to read that, the general principle of the common law. And that's the point about temporary absence not resulting in a person not being subject to jurisdiction. And if you read Lawrence Colin Jay's statement of principle, it remains correct.
Yes.
And then no answer, an individual has no connection with the jurisdiction, may be personally served if he's here temporarily. If he is here, he is, to state the obvious, he is here. Well, that's precisely the point, in a sense, because it's the territorial jurisdiction that matters. Doesn't matter how long you are here, but you have to be here.
What is the position in terms of precedent and whether we are bound or not by what Justice Stanley Burton said in these two paragraphs, 56 and 57? It does seem to be an integral part of his reasoning, leading him to conclude as he does.
Yes.
And I can see there could be an argument, and that means whether we like it or not, we're actually bound to follow it in this court.
Well, in my submission, you are, because of the way he's explained Kamali. Yes. I mean, it's not a case in my submission where there are two, as it were, different views expressed by the Court of Appeal. But so as a matter of precedent, I would say you are bound by that reasoning. But in my submission, I hope I've shown that reasoning and decision is absolutely right as well. So at this point in my submission, you come almost full circle to what was said by the Earl of Selborne about constructive presence by virtue of temporary absence.
Yes.
But if there is simply a last known residence test, you have the problems identified in all the cases we've looked at in relation to that. The long arm jurisdiction, which is, in my submission, exorbitant in those circumstances. It circumvents the service out provisions, reduces jurisdiction to a quirk of administration, and there is no sound basis for it.
Yep.
Well, that deals with, as it were, the fundamental point.
Just ask you, what do you say is the analysis? What is Stanley Burnton, or just Stanley Burnton, saying about the precedent status of Rolfe and Marshall?
Well, in my submission, he is saying he's not saying it's wrong, but he's saying it is purely a question of interpretation of the county court rule.
Well, I find it difficult to see what he says about Rolfe, except that the facts were extraordinary.
Yes.
And indeed, so they were, but it's not easy to see why he feels able to distinguish Rolfe. And although, as you rightly say, he says he agrees with the decision in Kamali, he reaches that conclusion for reasons which are very different from the reasons which the court in Kamali expressed. So just going back to the question that my Lord Sir Launcelot Henderson asked you, it might well be said that there are indeed conflicting authorities, in which case we may choose between them.
Yes. Quite. But in relation to that, I mean, what I think I would say is that the reasoning of Lord Justice Stanley Burnton relies, I mean, he goes back to the decision of Lawrence Collins. And Lawrence Collins said, Justice Lawrence Collins, made quite clear that in his view, in his judgment, that was just a construction of the county court rules and didn't have wider application.
Yeah, but Mr. Justice Lawrence Collins' decision wasn't binding on this court in either Kamali or SSL. It was a first instance judgment.
Absolutely. But in terms of his reason, and Lord Justice Stanley Burnton's reasoning on it, I mean, he refers, in my submission, his reasoning is based on Chalaram.
Yes.
That may not be express, but in my submission it must be implicit. Right. And finally, we have the point about confusing presence with residence. Now, as we've seen in the cases we've looked at, presence is not the same as residence. And we can see that from the fact the court can assume jurisdiction over a person who is served just by virtue of a fleeting visit within the jurisdiction. But it's because they're present within the territorial jurisdiction, not because they're resident here. And residence, for the reasons I've explained, is a question for the how of service and doesn't in any way connote or define presence. And we say in circumstances, again, where there's a prohibition on being present within the territorial jurisdiction, it is fundamentally incoherent to say there is jurisdiction by virtue of presence. And therefore, the court does not have jurisdiction. My lords, for those reasons, I would ask that the appeal be allowed.
Yes, thank you. Ms. Stevens, do you wish to add anything?
No.
Yes, Mr. Hayman.
grateful. There are two matters for me to address. Well, the first is whether there is an anterior common law requirement of presence for CPR 6.9 to apply. And the second is, if there is, whether Mr. Justice Bryan erred in his assessment of such a common law requirement in the circumstances of this case. Our position as respondent is that there is no anterior requirement of presence under the common law. But even if there is, on the multifactorial analysis of this case, Mr. Justice Bryan was right, for the reasons he gave, to conclude that such requirement of presence was satisfied. And I'll deal with each in turn.
Yes.
At root, in relation to the main issue of the common law requirement, our submission can be boiled down to two propositions. The first is that CPR Part 6 is a self-contained set of rules that do not require presence. Our submission will be that those rules do not have an obvious gap or space that needs to be filled by an independent extraneous requirement being read into them. And the second point is that the decision and reasoning of this court in Kamali, we say, is exactly on point. Namely, its finding that with the introduction of the civil procedure rules, there was no, or certainly was no longer, an anterior requirement of presence in the case of an individual defendant, and that the validity of service is to be determined by reference to the civil procedure rules alone. We will submit that the Kamali case is correct and binding on this court, at least in the case of service upon an individual, which is what was in issue in the Kamali case and which is in issue in this case. And I'll come on to say why SSL can be distinguished as a different case, because that was dealing with service upon a company. My learned friend at root bases his appeal on the dictum of Mr. Justice Lawrence Collins, as he then was in the Chalaram case, which was a case that was shortly after the introduction of the civil procedure rules. 2 points on Chalaram, my lords. The first point is that Mr. Justice Lawrence Collins, as he then was dictum, which your lordships have already seen, which states that the existence of a fundamental common law rule that presence is required was strictly obiter. And that is because, as we saw, and it was paragraph 47 of that authority, on the facts, CPR 6.5 did not apply because the address for purported service in that case was found as a fact not to be the defendant's last known residence.
I'm not sure about that analysis. If a judge gives two reasons for a conclusion, why can they not both be ratio?
Well, we say the factual conclusion knocked out, as a matter of fact, the possibility of it being valid service, such that Mr. Justice Lawrence Collins' then assessment of whether or not a common law rule applied and his dictum was not determinative of the issue.
But in a way, it doesn't matter because it doesn't bind us either way.
Indeed, Lord. And which is why I'll need to come on and deal with SSL, which, as my own friend said, piggybacked on the back of the Chalaram dictum. The second point is that Mr. Justice Lawrence Collins referred to two cases in the Chalaram case, said to be in support of the existence of the common law rule. And they were the Barclays Bank, Swaziland and Hahn case and the Cadogan Properties case. And it's our submission that neither of those cases is support for there being a common law rule. And we will later come on to see, or your lordships have actually already seen the references in the judgments of Lord Justice Newberger, as he then was, and Lord Justice May in the Kamali case, where they reached the same conclusion, that the Hahn and Cadogan Properties cases were both cases based on the construction of the rules and nothing else. The Barclays Bank and Hahn case, my lords, which is at tab 10 of your authorities bundle, that was a 1989 case. It was before the civil procedure rules in relation to the old Supreme Court rules. And the Order 10 of the rules of the Supreme Court expressly provided that a writ for service on a defendant within the jurisdiction may be served by post or by leaving it in the appropriate letterbox. So the court in the Hahn decision was concerned with construing the old rules of the Supreme Court, which contained expressly the words within the jurisdiction, words that we do not now have within the civil procedure rules. And the question that came before the Court of Appeal first was whether the words within the jurisdiction were referable to the place of service of the writ or referable to the location of the defendant. And we make the point in Respondent's skeleton argument that all three members of the Court of Appeal came down on the former meaning, i.e. the place of service of the writ had to be within the jurisdiction and not the location of the defendant. And what that outcome meant at the Court of Appeal level was, importantly, that the question of whether physical presence was required within the jurisdiction was answered by the Court of Appeal by reference to the rules as a matter of construction, and not answered by reference to anything else. When the matter came before the House of Lords, there was a single speech by Lord Brightman with which all the other lords agreed. And I don't need to take your lordships to it because you've just been taken to it, but Lord Brightman agreed with the common sense approach of the Court of Appeal that differed on the interpretation of the words within the jurisdiction. He favoured the opposite view.
Yeah.
He took the view that the location of the defendant over the place of service of the writ. But he reached that same result, we say, of validity of service on a reading of the rule that service was effected on the 7th day after service through the letterbox, or a different date, as my lord picked up, if the contrary is shown. When, as a matter of fact, the defendant had been in the jurisdiction. And so the effect of Lord Brightman's judgment is that Order 10, under the rules of the Supreme Court, was satisfied on its wording. Again, the question of construction. So we say ultimately, in the Swaziland, Bank and Swaziland and Hahn decision, the writ was validly served within the jurisdiction based on the meaning and effect of the rules of the Supreme Court at the time as to service, and not by reference to any independent common law requirement. And so we say Hahn was not a case which invoked or established any common law requirement of presence, and nor was it, with respect to Mr. Justice Lawrence Collins, an illustration of the principle as he expressed it to be in the Chellerham decision. The other case is the case of Cadogan Properties. Mr. Justice Lawrence Collins cited the Cadogan Properties again as giving him support because he said it was an illustration of the application of what he described as the common law rule. We do not understand that, and nor did Lord Justice Newberger and Lord Justice May in the Kamali decision. That was a different sort of case in the Cadogan Properties Authority. It was a service out case. It was a case about service on a company. It was obviously under the rules of the Supreme Court, not the civil procedure rules. And it was not a case in which service could be effected within this jurisdiction in accordance with the rules at all, unless an order for substituted or now alternative service was obtained. So we say that decision has no relevance or support for the dictum we see in Chellerham. So we submit that the dictum of Mr. Justice Lawrence Collins in Chellerham is not supported by the authorities he cited, and it is a decision on which, though rightly commanded respect, as Lord Justice Newberger said, it was one which stated the existence of, to use his words, a fundamental rule, surviving the introduction of the civil procedure rules, but without, we say, any underpinning. And so the question on this appeal, the question whether there is a common law rule that an individual defendant can only be served with a claim form within the jurisdiction if he is present here, was squarely before the Court of Appeal in the Kamali decision. And we've seen that the court unanimously concluded that there was no, or at the very least was no longer, an anterior requirement that the defendant be present in the jurisdiction. We say that decision is precisely on point for this appeal because it concerns service upon an individual. The question there was whether the individual could be served with a claim form at his place of business in accordance with the then Rule 6.56 in circumstances where he was outside the jurisdiction at the time. Now, at that time, CPR Rule 6.5 was the provision in order. Your Lordships will be aware that the numbers of the rules in the CPR have switched around and chopped around over the years. That's now the equivalent of CPR 6.9, albeit with some significant differences. And I'd like to address your Lordship on those differences, my Lords, on those differences. If I can ask you to turn to Kamali in the authorities bundle.
Yes.
Lords, we see Rule 6.5 set out in the footnote on page 323. And it provided, importantly towards the bottom, 3.56, where the party has not given an address for service, the document must be sent or transmitted to or left at. And then one looks at the table which provides where the party is the proprietor of a business, his place of business or last known place of business. Now, on the fact the defendant was served at his place of business, but the defendant was abroad at the time, and the defendant contended that the claim form had not been duly served as he was out of the jurisdiction. My Lords have I know, seen the judgment of Lord Justice May. I was going to go through it, but I'm conscious that my learned friend has already taken my Lords through it, and I don't want to just use time doing the same thing. But what we draw from Lord Justice May's decision is that it was a decision precisely on the point before my Lords today, whether the individual defendant could be served with a claim form. It was a decision under the civil procedure rules. He determined that the dictum of Justice Lawrence Collins and Chellerham was wrong for two reasons. He said it was wrong intrinsically.
What does that mean?
We take it to mean that it had no basis, and I'll come on to say why, because both Lord Justice May and Lord Justice Neuberger determined that there was no underpinning for the dictum, because, as Mr. Justice Lawrence Collins sought to rely upon the Hahn case and the Conducted Properties case, neither of those assisted him because they were cases of construction. And Lord Justice May also determined that it failed because it failed to follow, or was wrong because it failed to follow the decision in Rolfe, the decision on the county court rules. But in Lord Justice May's view, the decision on the same point, which was indistinguishable.
Yes.
And of course, the Rolfe case being a stronger case where the defendant had in fact emigrated to Spain. And Lord Justice May importantly made the point that any common law rule of presence was relevant in the days of personal service, for personal service would not otherwise be effective. Naturally follows. And that's in paragraph 6 and 14. But that does not apply now, or for the many years since methods of service other than personal service have been permitted. Lord Justice Neuberger reached the same conclusion. And what we draw from his judgment, again, I won't take my lords through it line by line, but I'll pick out some important points, is his conclusion that the words of the civil procedure rules do not exclude service in accordance with their terms simply because the defendant is out of the jurisdiction. That's paragraph 20. He was content to follow the decision in Rolfe because it dealt with the same point in relation to service on an individual. He did not consider Mr. Justice Lawrence Collins' reliance on the Harnack and Duggan properties assisted. And he reached the conclusion that the Chellerham decision, the common law rule, had been displaced by the introduction of the civil procedure rules. Well, then can I take you to where Lord Justice Neuberger deals with, I think, 6 points that he lists. He picks up at paragraph 25, the question of the overriding objective, and the fact that Mr. Woolman, counsel in that case, pointed to the risk of any unfairness. And what Lord Justice Neuberger does is posit the case of a foreign resident, paragraph 25 on page 331, who came here temporarily to work and after 6 months returned home, who while in this country unknown to him became allegedly liable during the time for a sum of money. On the view we have formed, he says, if proceedings were subsequently brought against him in this country, he would be liable to be served at his last known residence, namely the place he had lived in for 6 months. He makes the point in 26 that there's force in that point, but then goes on to say there are mitigating and compensating factors. As to mitigation, it is clear that before a claim form can be served on a defendant's last known residence in the country, the claimant has to have made reasonable investigations to find out where the defendant actually resides or actually carries on business. And what Lord Justice Neuberger does there is cite two authorities, Cranfield and Collier. He says, if as a result of those investigations the claimant discovers where the defendant is living abroad, then of course the claimant cannot rely on Rule 6.5 and must serve in accordance with Section 3, which at the time was the service out provision. And my
Which bit of CPR 6.5 says that?
Well, sorry, my lord.
Which bit of 6.5 says that
Indeed,
if you
well,
discover...
it's a point you raised, my lord.
Yeah.
It doesn't say it.
So where does
And this
Lord Justice Neuberger get that from?
Indeed. This is the point I was going to come on to. The rules have changed, and in fact they've strengthened. So what Mr. Justice, Lord Justice Neuberger was identifying there was a safeguard, a mitigating and compensating factor. One that he goes on to say strikes the balance of the interests of a claimant with a valid claim against the interests of a defendant. That requirement he drew from those two authorities, Cranfield and Collier Williams, both of which Court of Appeal decisions, which suggested that it would be appropriate when seeking to serve on a last known address within the jurisdiction for a claimant to at least take steps to discover whether that last known address was still being resided at or was somewhere else.
So, having said that you shouldn't start implying words into the CPR, that's exactly what he does in paragraph 26.
Well, he sees that as an important safeguard.
But where does he get it out of the rules?
The important point for today, my lord, is that it's now in the rules.
Right.
That provision has, if you like, been codified. And can I take you to CPR 6.9? Which is the rule under which
Yes.
the defendant in this matter was served. It's on page 248 of the current White Book. And it's headed, serves of the claim form where the defendant does not give an address at which the defendant may be served. And 6.91 provides that this rule applies where Rule 6.51, personal service, Rule 6.7, service on a solicitor, or Rule 6.8, defendant gives address, do not apply, and the claimant does not wish to effect personal service under Rule 6.5. And then importantly for our purposes, 6.92 then has these words, subject to paragraphs 3 to 6. Now, they're important because they are the newly codified rules, which provide the exact safeguards that Lord Justice Newberger had in mind. The claim form must, and we highlight the word must there because it's a mandatory provision, must be served on the defendant in the place shown in the table below. And for the purposes of today, the first entry on the table is to do with service on an individual, and it has to be served at the usual or last known residence. Lords, whilst we're looking at that table, can we just note that items 1, 2 and 3 all concern service on individuals, whereas items 4, 5, 6 and 7 concern service not on individuals. Well, that's important because when you then turn over to sub-rule 3, 6.93, that provides that where a claimant has reason to believe that the address of the defendant referred to in entries 1, 2 or 3, so that means that this only applies to service on individuals because those entries are only to do with individuals, is an address at which the defendant no longer resides or carries on business, the claimant must, again, it's mandatory, must take reasonable steps to ascertain the address of the defendant's current residence or place of business. So this rule, my lords, is contemplating the possibility of defendants who have ceased residing at their last known address. We then move on to sub-rule 4, where having taken the reasonable steps required by paragraph 3, which are mandatory, the claimant either ascertained the defendant's current address, the claim form must be served at that address. Now, well, that is essentially what Lord Justice Newberger was saying in the Kamali decision, and that's what we now see in the rules. And that mandatory provision in 4a includes, obviously, service out. So if upon carrying out reasonable steps to ascertain the address, it turns out the defendant's address is overseas, then the claimant is obliged under this rule to seek to serve upon that address overseas. Equally, if having carried out those investigations, the address is within the jurisdiction, the claimant is obliged to serve within the jurisdiction at that address. And then little b, and as I go through, you'll see that this is a mechanism, a set of rules that a claimant must go through in order to determine the place of service. Little b, if a claimant is unable to ascertain the defendant's current address having carried out reasonable investigations, the claimant must, again, mandatory, consider whether there is an alternative place to serve or an alternative method by which service may be effected. And then little 5, if under that process there is such a place where, or a method by which service may be effected, the claimant is obliged, must, make an application under Rule 6.15. Of course, 6.15 is the alternative service route. And just pausing there, my lords, that provision in sub-paragraph 5, such that if a place or method by which service may be effected is discovered by a claimant carrying out their reasonable investigations, that is an extra layer of protection, not envisaged or foreshadowed by Lord Justice Newberger, because at the time these provisions were not included in the rules. And then, also pausing there, I should say, this is the exact process that Mr. Justice Bryan had to consider in his decision as to whether my clients had taken these mandatory steps, and he found conclusively that my client had taken these mandatory steps, reaching to paragraph 6 at the bottom, subparagraph 6, which is where subparagraph 3 applies, i.e. where the claimant believes the defendant no longer, or has reason to believe the defendant no longer resides. The claimant may serve on the defendant's usual or last known address in accordance with the table that we saw. Where the claimant cannot ascertain the defendant's current residence or place of business and cannot ascertain an alternative place or alternative method. And so it was under CPR 6.9 subparagraph 6 that my clients were able, having gone through those mandatory steps, to effect service upon Mr. Fridman. And it's in paragraphs 26, 27, 28 of the Kamali decision, and Lord Justice Newberger's judgment, that he takes into account these mitigating and compensating factors. And at paragraph 27, he picks up, if the claimant has made reasonable investigations and cannot locate the defendant abroad, then he can issue proceedings and proceed to judgment, serving the claim form on the defendant's previous residence in this country, even with the defendant not knowing.
Sorry, which paragraph?
Paragraph 27.
27, yes.
And he makes the point that at 29, he picks up this point and says further, if a claimant with a good claim has taken the reasonable steps to locate the defendant in the example I've postulated, as he would have to do, and that's absolutely right, pausing there under the rules as they are now, then it would be unfair on him, the claimant, if, because the defendant had effectively disappeared, he could not bring proceedings with a view to enforcing his claim. Lord Justice Newberger makes the point that a balance has to be struck between the rights of a claimant and those of the defendant. And it seemed to Lord Justice Newberger that the balance achieved by the rule, as interpreted by the judge below, is fair and reasonable. And we commend that balancing of interests, particularly.
He's conflating two different factual situations, I think. You would have a factual situation where you've got an address for a person in, I don't know, Gloucester or wherever, but they've left that address and they've gone to live somewhere up in the northeast in Northumbria. You can't find them, but they are still within England. So that's one factual situation. The other factual situation is where somebody did live in England, but now they've gone to live in Timbuktu. The two may not be the same.
They may not be, my lord, and the way Lord Justice Newberger deals with the disappearing defendant, if I can put it like that, is that he says at 29 that if a defendant has disappeared, there's a risk that that will leave a claimant high and dry and unable to serve them anywhere. Now, that's a point that Lord Justice Newberger takes and we take in our skeleton argument, and we say it's a sound point, that we would be left with no place with which to serve Mr. Fridman. My learned friend in his skeleton argument says that's wrong. And he effectively said the same thing in his submissions this morning. He says the answer is that the provisions for service out in my lord's scenario where the person has disappeared overseas are more than capable of operating where the address or location of the defendant is unknown. Because what my learned friend says is that you then look to the decision of Mr. Justice Foxton, as he then was, Masharan, and you say that you can have alternative service back in London at the former home. But you can only have that alternative service order if you first go out and get permission to serve out overseas. we say our point that my client would be left high and dry is sound in circumstances where the claimant doesn't know in what jurisdiction the defendant now is. In Lord Justice Newberger's example, he posited a defendant who had effectively disappeared, that's paragraph 29. In our case, Mr. Justice Bryan observed paragraph 52(3) and 74 of the judgment that we, as claimant, did not know and had no way of knowing whether Mr. Fridman was either in Israel or Russia or elsewhere. And the reason we say this point is sound is because of what the rules require of a claimant. Can I take my lords back again into the white book and start at rule 6.6. Rule 6.6 appears in section 2, which is to do with service of the claim form in the jurisdiction. And it provides that the claim form must, so mandatory wording, be served within the jurisdiction, except where rule 6.72, that's service on a solicitor in Scotland, or 6.11, that's service by a contractually agreed method, or as provided by section 4 of this part, that's service out. So we will see that if one goes to section 4 in relation to service out, the claimant must then comply with its provisions in order to be able to serve. And we will see that compliance is impossible where a claimant does not know what jurisdiction the defendant is in. Well, can we first go in section 4 to rule 6.36. .36 is headed service of the claim form where the permission of the court is required. In any proceedings to which rule 632 or 623 do not apply, the claimant may serve a claim form out of the jurisdiction, so that's permissive as opposed to mandatory, with the permission of the court, if any of the grounds set out in paragraph 3.1 of the practice direction applies. And then 6.37, my lords. An application for permission under section 6.36 must, so this is a mandatory requirement of an application to serve out, must set out three things. A, which ground is relied on. B, that the claimant believes the claim has a reasonable prospect of success. And C, importantly, the defendant's address, or, if not known, in what place the defendant is or is likely to be found. As I say, taking Mr. Justice Bryan's findings, my clients did not know and had no way of knowing what place, Israel or Russia or elsewhere, Mr. Fridman was at or was likely to be found at. And so there was no way my clients in a service out application could comply with that rule. Further down within the same rule, 6.37(5) provides that where the court gives permission to serve the claim form out of the jurisdiction, it, that means the court, it will specify the periods within which the defendant may file an acknowledgement of service, file a defence, and so on. And again, that's a mandatory provision in the sense the court will do this. And we see at the bottom of the rule, the periods referred to in paragraphs 5A, 1, 2, and 3 are those specified in the table in practice direction 6B. However, we say this, if one doesn't know, or if a claimant does not know, and if therefore the court does not know where the defendant is located, what period must the court specify for those things to be done? The court cannot know. Lord, the next provision is 6.40, which is on page 315 of the White Book.
Sorry, which rule?
6.40.
Yeah.
This rule contains general provisions about the method of service of a claim form or other document on a party out of the jurisdiction. And then there are two headings where service is to be effected on a party in Scotland or Northern Ireland, and another heading where service is to be effected on a party out of the United Kingdom. And then it lists the methods of service. But importantly, sub-rule 4, towards the bottom, provides that nothing in paragraph 3 or in any court order authorises or requires any person to do anything which is contrary to the law of the country where the claim form or other document is to be served. So that provides that no method of service provided for can be contrary to the law of the country in which it's to be served. And that is a matter on which the claimant bears the burden of satisfying the court at the service out stage. And that's normally discharged with the use of expert evidence of law of the relevant country. And in the White Book at 6.40.3 in the commentary, which I don't know whether it's still in, or certainly in the up-to-date version of the White Book, whether it's in my Lord's version of the White Book, in 6.40.3, there's a second paragraph, long paragraph starting by virtue of 6.44, and about 10 lines down, the commentary records that the burden of proof is on the claimant to establish that service would not contravene the relevant foreign law.
Yeah.
And our point is simply, how can a claimant do that, I ask rhetorically, if a claimant does not know what jurisdiction the defendant is in?
But don't you sort of rely upon the judgment given by Mr. Justice Saney in October 23, in which he records that Mr. Fridman had travelled to Russia? So it's likely he's in Russia, isn't it?
Well, Mr. Justice Bryan concluded that on the evidence, he had first travelled to Israel and then on to Russia. That was the evidence before Mr. Justice Bryan. Mrs. Justice Bryan concluded, and I can take my lord to the references, that it was unclear which location he was in.
But do you have to identify a single location? Why can't you say, well, this man is either in Israel or he's in Russia. The method of service we propose does not contravene the law either of Israel or of Russia. Give us permission to serve out. What's wrong with that?
Well, just running through the rules I've gone through, it's mandatory upon a claimant to say where the defendant is.
Yes.
The question would be, does that envisage giving the court options as to where the defendant might be,
Or he's likely to.
or where he's likely to be? Indeed.
Can't seriously be suggesting that the court would be frustrated because somebody might be in Israel or in Russia. Surely the court can cope with that.
Well, I'm insisted by my learned junior. If the two options on the evidence were Russia and Israel, and the method of service in one was illegal, the method of service in the other was not, and to take my lord's point, the claimant turned up to court with those two pieces of evidence, how did the court then deal with permission to serve out?
But why can't the court say, you can serve the defendant in Israel by method A, and you can serve the defendant in Russia by method B, or alternatively, you can have alternative service at Appellant House?
Well, that brings me on to the next point, which is we say none of those points in the rules could be cured by getting alternative service at Appellant House, being an address in the UK, because you still need permission to serve out.
Yes.
Permission to serve out, we say, requires those mandatory rules to be complied with. We say it's an oddity if, in circumstances, a claimant could satisfy the requirements of CPR 6.9, which is the one Mr. Justice Bryan held we did satisfy. But because of a common law rule that is nowhere stated in the CPR, we then have to essentially be in breach of the mandatory rules for service out, or hedge our bets between various jurisdictions not knowing where the defendant is. But our point is that, as Lord Justice Newberger recognised, where a defendant has essentially disappeared, or where the claimant has no certainty and cannot know where the defendant is, a claimant with a valid claim is left with no way of serving originating process, because in those circumstances, on that scenario, the claimant could not satisfy the common law requirement of presence.
What you say is if that claimant just happens to know of an address the defendant was at in this jurisdiction, any time in the past, 20, 30, 40, 50 years ago, they can serve at that address under CPR 6.9.
Well, Rule 6.9 provides that if once you've gone through those mandatory processes and used reasonable investigations to find out where the defendant is, if the inquiry runs dry, you are entitled under 6.96 to serve at the usual residence, for which there's a test, or the last known residence, for which there's a test. And Mr. Justice Bryan held, neither of which holdings are subject to appeal, that Appellant House was both the usual residence of Mr. Fridman and the last known residence.
Testing now the proposition that whether this makes sense, and as I understand it, you would say that in a situation where you do not know where the defendant is, you have no way of finding out where he is. If you know, however, he resided at an address in England in the 1970s, but hasn't been in the jurisdiction since, you can serve him at that address. That must follow, mustn't it, from your argument?
Well, there might be a limitation issue.
Why?
Cause of action arose yesterday.
Very well, my lord. Oh, taking that scenario, I would answer that along the lines of the Rolfe decision. In the Rolfe decision, the last known residence, place of business of the defendant in Rolfe was 5 years back. He'd been emigrated to Spain for 5 years. But because of the county court rules, which we say are essentially identical to the now CPR rules, that last known address, that being the only last known address to the knowledge of the claimant, was an address at which the defendant could be served. And, my lord, adopting Lord Justice Newberger's decision and reasoning, there are now the safeguards built into 6.9 which require a claimant to jump through the hoops of making necessary inquiries. And ultimately, if those inquiries lead to service at an old last known address, there is the ultimate safeguard, which is if there's a valid defence, the default judgment that would be entered in the event that the defendant was not aware of the claim could be set aside. And it's that ultimate safeguard which Lord Justice Newberger felt fairly balanced the interests of a claimant with the interests of a defendant.
The answer to my question is that you do say that it could be served.
Well, my lord posits an extreme case, but ultimately,
Well, I think it's called reducing it to the absurd, isn't it? Not to use Latin.
I wouldn't use the word absurd, my lord, but my lord posits an extreme case, but under the rules, under 6.9, a claimant could satisfy good service upon that address if it was the last known address and only the last known address, after the claimant has carried out the necessary safeguard inquiries required under Rule 6.9, which are now codified, in the case they weren't codified when Lord Justice Newberger was satisfied of those safeguards in the Kamali decision. So ultimately, my lords, our position is that the Kamali decision is binding as to its ratio. It was a unanimous decision. It's on point for this appeal because it concerns service upon an individual within the jurisdiction. It's underpinned and supported by the decision in Rolfe, which is also on point because it concerned service on an individual under county court rules, which were, to all intents and purposes, the same as the civil procedure rules. And the court in Kamali directly considered whether a common law requirement of presence had survived the introduction of the CPR in the context of service on individuals, and decided emphatically that it had not. Now, the SSL decision in the Court of Appeal came along several years later. There's only a single judgment of Lord Justice Stanley Burnton, with which the other two Lord Justices agreed. The first point we make is that the facts in SSL were markedly different to those in Kamali, and equally different to the facts in the instant case. SSL was service on a company, not on an individual. SSL was a case of personal service on a company. And that's because the claimant could not bring itself within the equivalent of what is now 6.9, because the defendant, which was an Indian company, had no place of business in England and carried on no business here. And my lords will have seen that the SSL decision arose in a joint venture context. SSL had a right to appoint 4 directors to the board of the Indian company called TTK, which had no premises or business in England, so no connection whatsoever. And rather than the claimant seek to serve TTK abroad, SSL tried to serve TTK here in England by serving on one of the directors that they themselves had appointed under the joint venture arrangement, and who was also an employee of the claimant, SSL.
Yeah.
So they ended up serving themselves at their own office, a point that Lord Justice Stanley Burnton noted. And the question in SSL was the proper construction of the personal service rule, whether it permitted service on a person holding a senior position within the company, if the company or corporation did not carry on business or was not present within the jurisdiction. And given that question, our position in summary is that the SSL deals with a different point, and it's not binding on my lords. It's not binding in circumstances where we are dealing with service on an individual by post or by leaving at an address, which is what this case is about. This case is not about personal service. At the very least, SSL is distinguishable because it's to do with personal service on a company. And when one is considering personal service on a company, none of the safeguards that I've taken my lords through in Rule 6.9 apply. That regime only applies, as we saw, to individuals. We say there are manifestly different policy considerations to apply when thinking about service on companies and individuals. The question of where a corporation is present is different to where an individual is present, and the safeguards in 6.9 only apply to the latter and strike the balance that Lord Justice Neuberger observed. And our final point on SSL is that because the SSL decision is essentially obiter, because the question in SSL was regarding personal service on a company, insofar as that decision purported to speak to the position regarding an individual, and service on an individual by post or by leaving it at an address, it's obiter. So we submit that the court can and should affirm the correctness of the rules-based analysis as set out in Kamali, and for the reasons I've given, the decision in Kamali is binding.
Yes.
Now, my lord, there have been a number of first instance cases since SSL. I don't want to take long on them by reason simply because they're first instance cases and therefore do not have the binding effect. But two cases cited against me are both to do with service of witness summons, not claim forms. One is the Clavis case, Mr. Justice Warren. The other is the Libyan Investment Authority case, Mr. Justice Tier. My lords, I won't take you to it, but in Clavis, Mr. Justice Warren recognised the tension between Kamali and SSL, but concluded that he was bound by Lord Justice Stanley Burnton's explanation of Kamali. That was even though Mr. Justice Warren was concerned with service on an individual. What Mr. Justice Warren did not do, which we say was an error, was distinguish SSL, either because it was over to, because it was to do with personal service, or distinguishable on the facts.
Yes.
And in the Libyan Investment Authority case, Mr. Justice Tier simply adopted Mr. Justice Warren's analysis, concluding that service was valid, notwithstanding physical absence. And we will see later in my submissions that Mr. Justice Tier went on to equate residence with presence, which is a point that I can rely upon later. And my lords, against that, there are two first instance decisions which we say are in our favour because they have not followed SSL. The first is the case of Norcross, Mr. Justice Hamblin. But more importantly, and if I will, I'll take you to it for the short adjournment, which is the decision of Key Homes, which my lord should find in a supplemental authorities bundle.
Oh, is this Master Marsh?
Master Marsh.
Yes.
I'm not suggesting Master Marsh is binding on you, my lord.
No. But he was concerned with the Companies Act, was he not?
He was concerned with the Companies Act, but it is, we say it's an interesting and important decision because of the manner in which he goes about his analysis of the Companies Act. The starting point, my lords, is at page 6 of that bundle, paragraph 8, where he observes that the claimants have raised what is agreed to be a novel point concerning service. They say they're entitled to rely upon section 1140, and that by virtue of that section alone, disregarding the provisions of the CPR, service has been affected. At the bottom of paragraph 8, he says it's therefore convenient to deal with that issue first, and in the course of doing so, it's not going to consider whether there is an underlying conflict of law rule that a party may not be served while out of the jurisdiction unless that absence is a temporary one. So he's posing the question that is before my lords. And then paragraph 18 on internal page 8, he observes that Mr. Penny, who was counsel for the defendant, submitted that the effect of 1140, taking into account subsection 8 and its proper construction overall, is that it does not abrogate what he says is the general rule of conflicts law. The person may not be served at a time when he is not resident within the jurisdiction, unless that absence is temporary. It's therefore necessary to consider whether such a general rule of conflict law exists. And then in 19, he sets out the dictum of Mr. Justice Lawrence Collins, and then observes at the bottom of the page that that dictum has been considered in two cases which appear to express irreconcilable views, Kamali and SSL. And then, my lord, dropping down to paragraph 22 at the bottom of page 9, he observes, in Kamali, the claim form was served on the defendant at his place of business at the time he was abroad. Nevertheless, all three judgments of the members of the Court of Appeal clearly disapproved the dictum in Chellerham and held that the principle had no application to service of proceedings under CPR. And then goes on in 23 to recall that in SSL, a differently constituted Court of Appeal reached the opposite conclusion, and Kamali was distinguished. However, he says, the facts in SSL were markedly different from those in Kamali. Pausing there, I agree with Master Marsh. And SSL International concerns service on a company. Again, also I agree with Master Marsh. Rather than an individual, and the issue concerned the proper construction of CPR 6.53b, well, that's the personal service on a company provision. The Court of Appeal held that the rule did not permit service of the claim form on a company which did not carry on business within the jurisdiction. And my lords, finally, in this authority, dropping down to paragraph 24, Master Marsh concludes this: I'm bound to say, with respect, that I do not find it easy to reconcile SSL Lord Justice Stanley Burnson's acceptance of the correctness of the decision in Kamali with his approval of Mr. Justice Lawrence Collins' statement of principle in Chellerham, with the qualification he adds. It appears to me that the judgments in Kamali are expressed in wide terms, construed provisions of CPR 6 so as to exclude the principle described in Chellerham. However, SSL relates only to the provisions of 6.53b, being personal service, concerning service of a claim form on a company. This claim, so the one before Master Marsh, and Kamali relate to service on an individual. Although the distinction is a limited one, I consider that I am bound by the decision of the Court of Appeal in Kamali, which is underpinned by the earlier decision in Rolfe that Chellerham had no application to service on an individual. And my lords, there, as the case was to do with service on an individual, Master Marsh considered himself bound by Kamali and observed that Kamali was properly underpinned by the other Court of Appeal case in Rolfe. And the best I can do, my lord, is to commend that approach and commend a similar approach here, because this case is to do with service on an individual under the exact same rules that were considered in Kamali. Lord, I've so far focused on, or largely on, the case law. I was going to take my lords through the rules in an attempt to show my lords that there is not an obvious space or gap in the rules for any independent requirement to be implied into them.
Yep.
And nor is there any acknowledgement in the civil procedure rules that any old rule exists or is maintained.
Yes.
Well, part 6 is divided into 5 sections. It's at page 232 of the current White Book. And just looking at the contents page of part 6, section 2 deals with service within the jurisdiction, and section 4 deals with service out. Starting with service in the jurisdiction, the first rule to turn to is Rule 6.6, which, as we saw before, is in mandatory terms. A claim form must be served within the jurisdiction unless one of the 3 scenarios applies. We say none of them do. And so what we say 6.6 is doing is it is stipulating that if a claimant can meet any of the sections dealing with service within the jurisdiction, a claimant must use it. And we say that's important because firstly, a claimant is required to serve by the rules within the jurisdiction if it can. Secondly, a mandatory provision like that leaves no scope for ambiguity and does not say, oh, and the defendant must also be present in the jurisdiction. And thirdly, the service out rules are not mandatory but permissive, as Lord Justice Neuberger observed.
That clock's 5 minutes slow, in case you're wondering.
I'm grateful. I'll carry on. Rule 6.7, which is on page 245 of the White Book, provides for service on a solicitor within the jurisdiction. So where the defendant has given in writing the business address within the jurisdiction of a solicitor, that is the place for service. But again, we observe that that rule does not require additionally presence of the defendant. The defendant, him or herself, can be located or present anywhere. And on the plain meaning of that rule, while service takes place at an address within the jurisdiction, being the solicitor's office, the defendant need not be. Rule six point eight.
But wait a minute. You can only serve on the solicitor if the solicitor is instructed by the defendant to accept service of the claim.
Indeed.
So that's a submission to the jurisdiction, is it not?
It could be described as a submission to the jurisdiction, or as a waiver, I suppose. My learned friend would say as a waiver of the presence requirement.
But anyway, it requires the defendant's consent.
It does. Rule 6.8 serves as the claim form where before service the defendant gives an address at which the defendant may be served. The defendant may be served with the claim form at an address at which the defendant resides or carries on business within the UK and which the defendant has given. So, two requirements: must be an address at which the defendant resides and which the defendant has given. And that is specifying a residence test and not a presence test. And the rule requires residence, we say, is important because that is telling a claimant what the test is for that rule to apply. And we say there's no scope for extension or implication to an extra requirement of something different. And my lord, the next rule is rule 6.11 on page 254.
Well, 6.8a again entails the consent of the defendant. The defendant's given his consent for the purpose of being served. The Landlord and Tenant Act requires the provision of an address in England for service. So again, that's something that the defendant, or in the case of the Landlord and Tenant Act, the landlord has to do.
The point made against me, as I understand it, is that if there was an overarching requirement of presence under the common law, that requirement needs to be implied or imported into all of these rules.
Well, no, because the common law, the courts of this jurisdiction assert at common law jurisdiction over a defendant who has submitted to the jurisdiction. And these are forms of submission to the jurisdiction. You've given an address at which you agree you can be served. Or you've instructed a solicitor that you can be served. We are dealing with a potential defendant who says, I'm not here, I'm not living here, I don't consent to be served, which is a different situation from what we find in these particular rules.
What I'm trying to build on is a point that Lord Justice Newberger made, which was his reliance upon what is now 6.11, which I'm just about to come on to. Which is, again, another rule within the section 2 within the jurisdiction rules, where there is a contractually agreed method.
Yeah.
Well, that might be my Lord's point about a landlord and tenant lease, which provides for a contractually agreed method of service in the event of a breach of the lease.
Well, no, section 47 of the Landlord and Tenants Act isn't to do with contract. It's a statutory obligation to provide an address for service.
I knew I should have been careful before dipping my toe into the world of landlord and tenant. But my Lord, the point Lord Justice Newberger makes, and he considered to be informative, paragraph 22 of Kamali, made the point that this rule does not fall within the service out part of CPR, which suggests that the provisions outside the service out parts were intended to be capable of applying even where the defendant was out of the jurisdiction. And these are all examples where service is effected within the jurisdiction, but it doesn't matter where the defendant is.
Right. All right, well, would that be a convenient moment to break,
My Lord,
Evan?
My lord, it would. I think I'm either very close to or at the end of my
Right.
submissions on point one, but I'll reflect over the short adjournment.
I would like you, if you would, to deal with this question. If there ever was a common law requirement of presence for the purpose within the jurisdiction for the purposes of valid service, what power did the Rules Committee have to change the substantive law of jurisdiction? Thank you. 2 o'clock.